mean, that's the day, I mean, that's the cost savings.
Give them potential dates.
Good morning.
Oh, good.
I'd like to, in the process of calling the meeting to order, I'd like to remind everyone to please turn off their cell phones and for the board members to keep their smartphones off the tables so we can avoid feedback. We will, this is an official meeting of the Medical Board of California, and so we're going to conduct this in as effective and efficient manner as possible. I would ask all speakers to keep their comments to 3 minutes. We have a lot of meaty agenda items today, and so members of the public and those who've submitted slips, we're going to ask you to keep your comments to 3 minutes. There will be a designated time on the agenda for public comment on each agenda item, and we welcome, as I said, we welcome public comment on any item on the agenda. If I am forgetful and forget to ask for it, someone up here will poke me. And we will also begin with agenda item, public comment on items not on the agenda. I would ask anyone who would like to speak either on an agenda item or prior to that on items not on the agenda to either fill out a slip now or after you speak. And if in the course of public comments you decide you'd like to speak, just raise your hand and I will recognize you. We are going to work through lunch. We are not going to be holding our closed session at the end of the meeting today, so we're going to work through lunch and attempt to give folks best shot at getting out early. We are going to take we're going to take a couple of agenda items out of order. So we have a couple board members who still have not arrived, and I want to be certain that before we start the regulatory hearing, we have everyone here. So I'm going to call the meeting to order now and ask Ms. Toof to please call the roll.
Dr. Levine?
Here.
Mr. Serrano-Sewell?
Present.
Ms. Diego? Dr. Bishop?
Here.
Dr. Gonadev? Dr. Kraus?
Here.
Dr. Lewis?
Present.
Denise Pines? Here. Ms. Shipsky? Mr. Tagami? Ms. Wright? Ms. Yaroslavsky? Present. Dr. Yip?
Here.
Thank you.
We do have a quorum. I'm going to move to agenda item 22, public comments on items not on the agenda.
Good morning,
Yeah.
Geneviève Claverol. I want to deal with an issue of patient abandonment from one of the physicians in Pasadena, California. Dr. David Martin, who is a specialist in a lab band surgery.
I'm sorry. Please don't speak about a specific case that may come before the members, but you can speak in generalities.
Okay. So what can you do when a physician does abandon a patient and falsify letters about that patient?
File a complaint with the medical board.
Okay.
That it would be the basis of a complaint.
Yeah. What's the length of time from the time you file a complaint that some action is taken?
I'm sorry, we can't do a question and answer.
Okay, no, you're right. I know better than that. Thank you. I forgot.
But someone can help you at an appropriate time to walk you through the process.
We're still missing two. Oh, one board. Okay, I'm going to, Ms. Harold, I'm going to,
Are there any other public comments?
oh, sorry, any other public comments on items not on the agenda? Then I'm going to, Ms. Harold, if you would join us, and I'm taking this out of order. Thank you so much.
Thank you for the courtesy of hearing from me and also for putting me first, so thank you very much. It's an pleasure to be here. I'm Virginia Harold, or Jenny Harold. I'm the Executive Officer of the Board of Pharmacy, and in collaboration with the Medical Board, we're working together on various projects, and then Ms. Kirkmeyer is coming to our board meeting next week to provide an update on what the Medical Board's been doing, and this is my opportunity to update you on what the Board of Pharmacy is doing. So, we have had, like you have, a busy year this last year with legislation. We secured legislation that is going to have the Board of Pharmacy literally do inspections of all hospitals in the state, outside the state, or any other pharmacy outside the state that's shipping sterile compounded product into the state. This is in light of the New England Compounding Center tragedy. There's nothing else, or public health tragedy, that is going to ensure, at least for us, that if medication is shipped into the state, the facility will at least have been inspected by us. Many states don't have boards of pharmacy that are able to do inspections, and so a lot of these pharmacies are doing this very high-level, dangerous form of compounding without appropriate oversight, although that seems to be going away now in light of the 63 people that have died. So we're gearing up, starting in July, that right now hospitals under an accreditation process, some are doing sterile compounding without being inspected directly by us. That accreditation piece has now been removed, requiring now annual inspections by the Board of Pharmacy if they're doing high-risk sterile compounding. And sterile compounding, we've redefined it so that it includes injectables, eye administration, or inhalation therapy products. So we're working on that. We have 38 inspectors. We're adding 4 specifically for this one function, and we hope to ensure that at least the quality of the medication, at least at the point of time that we do the inspection, meets California standards. And our standards are a little higher than most of the rest of the country. So we're hoping to provide consumer protection there. I'm pleased to announce that we are going to be collaborating again on a couple of more protocols, thanks to the legislation that was enacted this year as well. We have completed the fact sheet on emergency contraception, which was one of the requirements that when a pharmacist provides emergency contraception, they're required to provide this fact sheet. The protocol was approved, I think, in February, so everything's in place. We're now having this translated into 6 languages, and it's available on our website. But pursuant to Senator Hernandez's bill that provided additional duties for pharmacists to perform, your board and our board have been directed to collaborate on development of protocol for hormonal contraception therapy, and then also for smoking cessation products. So we are going to begin the process from our end with a meeting in December. We haven't yet started anything, at which point we'll expect Ms. Kirkmeyer to attend, and then we'll find a way to do the liaison between the 2 boards. But we look forward to doing this. We know in the past that ACOG has been very helpful in the development of the emergency contraception. I figure it'll be very similar to what we've done there, and then the smoking cessation, who knows? But we're looking forward to doing that as well. So you're going to get to see more of me somehow or another. Electronic pedigree. This is the process by which you tag each saleable unit of a drug so that you know where it's been at every change in ownership. So someone can't buy drugs off the internet, out the back door, take drug samples, or do any number of other things, slip the quantity into the drug supply without there being an observation or at least some risk of being caught. Right now, there's virtually very little risk for some of those forms. The real intent is to safeguard the supply chain. The requirements kick in for manufacturers where 50% of their products sold in California in January 2015 have to be serialized, and then the remaining 50% in January 2016. The pharmaceutical supply chain, which includes manufacturers and wholesalers and pharmacies, and to a degree the physicians are part of that, but they're not actively involved in this. But there's federal legislation pending that would preempt us, and they expect a vote next week. The one thing the members of the supply chain have decided is that one thing that we can all agree on is let's preempt California and then put in place a track and trace system in 10 years. So that's kind of what we're looking at there. We believe that the bill will be passed, but we're waiting for federal action, which is sometimes difficult to predict. And they thought they'd had it 15 months ago, and we're still promulgating regs. So we have done a series of regs. In fact, we have a reg hearing at our board meeting next week to deal with drop shipments, which is one that would clearly affect physicians, where a lot of manufacturers ship product not using a wholesaler, ship directly to the physician for administration. And these are typically the more expensive, high-risk drugs to begin with, but the wholesaler actually does the paperwork and actually ends up owning the product, but never possesses the product. So we're working around so that you don't have this anomaly. How do you append a pedigree that you never, for a product you never have? So we're just leaving out the wholesaler on that. It's a very secure method of distribution, and it doesn't really warrant some of the problems. So we're doing that. We're continuing to move forward with the regs, because if we don't, and there is no federal legislation, we will have a problem with the drug supply come January 2015, which we may have anyway. If anybody has questions, feel free, because I'm just going to kind of quickly tick through these things. Our patient-centered regs, which standardize the requirements on a label so that they have information that patients can see that would be comparable regardless of what pharmacies they go to, where basically patient name, drug name, and strength, directions, and then purpose if it appears on the label. Those labels we committed to evaluating the regulation by December 2013. We've completed that process. We've made a couple of tinkering modifications to the requirements that the board will act on, or at least consider next week. One of the recommendations is to increase the size of the font. Right now the requirement is 10-point, with a requirement you do the labeling in that patient-centered area to 12-point, which is slightly larger. The board has gone ahead. 70% of the pharmacies are already going straight to 12 anyway. So we're going to make the requirement 12. Consumer groups, senior groups in particular, were very adamant about that. Industry was very strongly opposed to it initially, because they were concerned that it was going to force a bigger container. It didn't occur. People have been able to accommodate. So that's next week. And those are the major issues that I want to discuss with you that we're moving forward with at our board meeting. We have one interest in common, which is the next agenda item with you. So,
Ms. Yaroslavsky?
So I want to thank you for that, but what I heard you say that's going to be on the label is the purpose according to the...
There's, purpose, if it appears on the written prescription, appears on the label. The purpose is not the diagnosis. No, it would be for headache, for your heart,
for pain, for
that very generic term, so that you would not have a patient privacy issue. But patients frequently don't know why they're taking their meds.
Neither do their caregivers. So the issue...
Exactly.
So, yeah, no, I have a problem. So what I'm trying to understand is, though, that means that the doctor, when writing the prescription, has to write the purpose, or that means that the medication that has a label that comes with it from the company telling you about indications, what purpose is...
Under California law currently as it stands, if the physician writes purpose on the prescription document itself, then the pharmacy labels it with that information on the prescription container.
Good.
But it is not a pre-printed, pre-assigned number based on what a particular drug would normally be used for, because a lot of times drugs are used off-label.
Okay, so, okay. Thank you.
So it's something that would be the physician, if the physician enters onto the prescription purpose, then the pharmacy puts it on. And that's something we may want to work with you on too a little bit. We would like to see purpose on the label generically, because it's important. It helps prevent med errors, and it also helps the patients, again, and their caregivers, take the meds and why they're taking it.
Good, okay. I mean,
Dr. Yip?
Yeah.
It's a good step forward, but as Barbara mentioned, that in reality, let's say a patient taking terosozine for the purpose of BPH, prostate, most of the pharmacy I have seen, they put down high blood pressure. So that's the purpose for them. So I think in the long run, the medical field and pharmacy need to work together, some kind of regulation. Otherwise, I have patients actually come and say, I didn't take the medicine because for blood pressure. So.
Well, and as a physician, it would be very beneficial if you could kind of key in a little bit something not sexually transmitted disease or something to that degree that you wouldn't want to do that, but you could put infection or something along that line.
It's STD. You don't have to write sexual transmitted disease.
Some acronyms may be more effective than others, maybe. I don't know.
Ms. Harold, one question about the electronic pedigree. How will that impact the samples that drug company reps leave in doctors' offices?
As long as they stay in the doctor's office and don't get near a pharmacy, no impact at all. The problem is sometimes they find their way into pharmacies, and that is a problem. They don't belong there.
Dr. Gananadev.
The purpose worries me. Some aspects, you mentioned sexually transmitted diseases. It could be any drugs related to Viagra. I mean, what you going to write? I mean, it's just a little worrisome.
Just write little blue pill.
But what my question actually is, you mentioned about you going to the hospitals to look at the pharmacy if they're doing any, and all the items you mentioned are routinely done in hospital pharmacies. Do you plan to go with CDPH, or do you plan to go with Joint Commission, or you plan to go separately, unannounced? What's your plans?
Separately, unannounced. Public Health and the Board of Pharmacy communicate back and forth. JACO will not give us their accreditation reports. When there's a violation, they will not share the violation with us. And that is a public health issue for us.
If there are no more questions from the board, any public comment on Ms. Harold's presentation? If not, I want to thank you very much for coming. We really appreciate it. Yes, so while you're here, let's just move on to agenda item 26.
Okay.
Thanks.
All right. I just wanted to let the members know we're still planning on having another forum like we did before with the joint forum with the pharmacy board on prescribing issues. We'll be looking for it in mid-2014 just because of issues that are both pressing for both the pharmacy board and the medical board. We're probably not going to be able to do it in the spring. We'll probably look in mid-2014, and it will be in Southern California. We're really trying. We'll see what date we can look at for between the two of us. Several of the outcomes and need for educational materials from the forum have been transferred to the board's Education and Wellness Committee. And then also I wanted to let the members know in regards to a similar forum, we were contacted by the Assistant U.S. Attorney from the United States Department of Justice, who's working on a summit on prescription drug abuse to be held in early January 2014. They'll be inviting local, state, federal, law enforcement, educators, and several other interested parties to the summit. We'll be working with them, as will the pharmacy board, and also with Dr. Levine to do a presentation from the board at that summit. So we're looking forward to that as well. So we have two events coming up in 2014. And Ginny, if you want to add anything on the forum.
With respect to the forum, I think you covered it. One of the things that we're doing at the board, and this probably isn't too beneficial for physicians, but some of your healthcare practitioners may be wanting to do this. Very similar to what we did at the forum, we are doing day-long seminars with the DEA. We're giving pharmacists 6 hours of CE to attend so that they get familiar with the typical kinds of drug diversion schemes that the DEA enforces. They talk about prescription drug abuse, the sheer quantity of drugs that are now moving through our drug supply and its impact on public health. We then get up and we talk about corresponding responsibility, which is a pharmacist's obligation to review the prescription to make sure that it's not harmful to the patient or it's otherwise legitimate. So those are day-long seminars. We did 6 of them this summer. 6 days worth, and we've done them in Southern California and San Jose. So we've pretty much covered the area now. We've got another one scheduled for January in Santa Ana or somewhere in Orange County, so we're coming back down here. I don't know whether or not physicians would be interested in part of it. The segment dealing with corresponding responsibility, probably not so much, but the rest of it is pretty generic to good dispensing and good prescribing practices. And the other piece that we're looking at is the education piece for high school and junior high kids, where we're looking at some way to connect with the curriculum and help start working the kids through so that they think twice before they go through grandma's medicine cabinet to get a drug.
Do you want to speak about the drug take-back?
Any questions from Ms. Kirkmeyer or Ms. Harold? Dr. Serranos, Mr. Serranos.
Got an increase in...
Is passing out degrees?
Finally. Well, I just wanted to add to the the conference that'll be happening. I think it's going to be at UCSF Mission Bay campus with the U.S.
Yes.
Attorney. Yeah.
Mhm.
So I had a wonderful call. I had a call from a former colleague of mine at City Hall, Anne Marie Conroy, who's a senior advisor to the U.S. Attorney for the Northern District of California, our local prosecutor, federal prosecutor, and wanting to get involvement from the medical board and the pharmacy board. And so thank our executive director and president and yourself for agreeing to be a part of it, because I know it's another thing to do, but we're going to be able to now help shape that dialogue so the feds understand, like, they're going to have an agenda, they're going to want to do something, and by working in conjunction with the state, we can provide them the resources, so we're working together.
And I think one of the things I meant to mention, and I didn't, I noticed that at the federal level, in the same vein, we've got the Federation of American Medical Examiners, or whatever your federation is.
Federation of State Medical Boards.
Thank you. I knew I was going to blow it. Well, and then the equivalent agency for both pharmacists and for registered nurses meeting to try to work together too. So it's good that we're doing this collaboration. And yeah, and then tomorrow is Drug Take Back Day, so anybody that's got extra prescription drugs, if you put in your area code, you go onto a website. Both the medical board has a link, we have a link on ours. You can find a local community event where you can dispose of your drugs without cost. We believe, according to the Drug Enforcement Administration, they believe that they will have guidelines for drug take-back programs in place in December. They solicited comments in February. Currently, California used to have model guidelines for how to take back drugs. The feds look very much like what ours look like, so it's good. We've had an impact on federal law there too. There was a link. I just finally got there. But we don't know yet until the DEA releases their guidelines. The issue of how you separate that controlled drug out when you do drug take back, where it's a federal crime if you do it the wrong way, is kind of stalled. So we're hoping that the requirements get released so that we can move forward. And then, as I'm sure you're all aware, that yesterday the FDA came out with a proposal to make Vicodin or hydrocodone a Schedule II drug.
Which should at least have some impact on the amount of drugs circulating in the environment.
Well, in California, since we seem to be way out front with hydrocodone, there'll be an impact there. So.
Excuse me. Any other questions from board members? Members of the public? If not, thank you so much.
Thank you.
Apologize. Let's move back now to, we'll go back in sequence with our agenda, and I want to move to the next agenda item 23, which is a public regulatory hearing. For the record, good morning, my name is Dr. Sharon Levine, President of the Medical Board of California, and I will be presiding over this hearing. This is the time and place set by the Medical Board to conduct a public hearing on the proposed regulations to implement, interpret, or make specific changes to sections 315, 315.2, and 315.4 of the Business and Professions Code. The Medical Board of California is considering changes to Division 13 of Title 16 of the California Code of Regulations as described in the notice published in the California Regulatory Notice Register and sent by mail or electronic mail to those on the board's mailing and subscriber lists. SB 1441 required the Department of Consumer Affairs to establish uniform standards regarding substance abusing licensees, focusing on the areas of intake and how licensees are monitored after they are placed on probation. This rulemaking will incorporate the uniform standards for substance abusing healing arts licensees as required by SB 1441 by proposing to add the standards for a licensee who is placed on probation due in part to a substance abuse problem, allowing the board to impose conditions which will ensure public protection. For the record, today's date is October 25th, 2013, and this hearing is beginning at approximately 9:35 California time. We ask that persons who wish to testify please fill out a speaker slip, and I have several here, which are available at the back of the room. The purpose of the hearing is to receive oral testimony concerning the regulatory proposals described in the notice. Regulations must comply in general with 6 legal review standards. Number 1, necessity. Is there demonstrated evidence that there is need for the regulation? Number 2, authority. Does the board have legislative authority to adopt the regulation? Number 3, consistency. Does the regulation conflict with other regulations or statutes? Number 4, clarity. Can the regulation be easily understood by those impacted? Number 5, non-duplication. Does the regulation duplicate other regulations or statutes or requirements? And number 6, reference. Which statute does the regulation implement, interpret, or make specific? And testimony today should address these 6 standards in relationship to the promulgated regulations. Before we begin, I want to briefly describe the procedures we will follow. The entire hearing will be tape recorded. Persons testifying will not be sworn in or cross-examined. All recommendations and objections will be considered by the board members. Responses to all objections will be included in the final statement of reasons. The board will maintain a rulemaking file of this proposed regulatory action. Written comments for the regulation being heard today were received by 5 p.m. on October 22nd, 2013. The recording of this hearing, written testimony, and all written comments which were received by October 22nd, and we had numerous comments that were received on the 22nd, will become part of that rulemaking file. And we have, for the record, public comments have been received, have been distributed to board members, and I believe we have copies of the comments on the back table for anyone in the room who's interested. And a completed copy of the rulemaking file will be available for review at the medical board's office in Sacramento to ensure fairness and completeness in terms of everything being completely entered into the record, and to enable everyone to hear those who are giving testimony. We ask that those of you who are testifying please follow these procedures. Please speak loudly and clearly. Identify yourself and who you represent, and then state your position, either in support or oppose, or I assume also offering recommendations or modifications at the beginning of the testimony. Oral testimony will be limited to 5 minutes per person for purposes of this regulatory hearing. Please do not repeat testimony that's already been given by a previous speaker. And if you have written comments with you today, please summarize them and then give us copies of the comments so we can be sure that they are incorporated into the file. It is my understanding that staff has recommended amendments to modify the language. After legal counsel's explanation of staff's recommendations, I will call on those persons who are interested in testifying. The amended language Ms. Webb will be going over was posted on the board's website on October 11th, 2013 with the meeting materials. And the comments we have received to date are in response to those amendments that were published on October 11th. Ms. Webb will now go through the amendments. And please be, also just one other thing, be aware that we will not be, the board members will not be commenting on or responding to testimony. Our goal is to be certain that the record incorporates a complete record of testimony given. Ms. Webb?
Okay, thank you. I'd like to have the members turn to their board materials, BRD 23-22. That is the first page of the amended proposed regulations. And There are some minor changes, capitalizations, commas, that you can see those for yourself, but I want to make sure that you're aware of the new substantive changes that are in the language. So on page 2323, you'll see that the language has changed from be randomly drug tested to undergo random biological fluid testing as being more inclusive. And biological fluid testing is identified and defined in this language. On page 2324, subsection F, this should have been included in the original language, and that is that no licensee shall be returned to practice until he or she has at least 30 days of negative biological fluid tests. Page 2325, we struck out some language to make subsection 4A more clear. We struck out the board may impose participation in group support meetings because the first part of that and the last part it clearly defines what the board can do. On page 2326, again, we just struck out the random drug testing and made it more inclusive, undergo random biological fluid testing. And under 1 subsection 2, again, biological fluid testing, and then this language was missing and should have been included originally, that prior to vacation or absence, alternative biological fluid testing locations must be approved by the board. Under subsection 3, again, the change to biological fluid testing. And under 4, the similar changes there, and the last part of that sentence is licensees shall be tested on the date of notification as directed by the board. Down to subsection 7, the change there is that licensees shall contract with a laboratory or service approved in advance by the board, provided that the laboratory or service meets all of the following standards. And on 2327, the next change is under subsection 6, clarifying that the entity shall process and analyze the specimen and provide legally defensible test results to the board within 7 business days of receipt of the specimen. The board will be notified of non-negative test results within 1 business day and will be notified of negative test results within 7 business days. Under 6A, we're including that the board shall also immediately notify all the licensee's employers, if any, and workplace monitor, if any. Page 2328, those 2 changes on that page just clarify that it's biological fluid testing. And then the final change on page 2329, same thing, expanding drug testing to biological fluid testing, which has been defined to include urine, hair, breath, blood, so it's all-encompassing. Thank you.
Okay, I have 4 slips for testimony. So if there's anyone else who has not submitted a slip to provide testimony, please fill out a slip. And Ms. Toof, raise your hand so we can see where you are. The first slip I have is Julie D'Angelo Felmuth.
Good morning, Dr. Levine and members. I seem to have picked up whatever bug you have. My name is Julie D'Angelo Felmuth. I'm the Administrative Director of the Center for Public Interest Law at the University of San Diego School of Law. I served as the Medical Board Enforcement Monitor from 2003 to 2005. CPIL supports the proposed regulation so long as it is significantly amended to be consistent with the uniform standards regarding substance abusing healing arts licensees, and the version of those standards is dated April 2011. I submitted some detailed written testimony to you on October 22. So I want to kind of hover at 50,000 feet and provide some background information, especially for the new members. 5 years ago, in 2008, the legislature recognized two things. First, a substance abusing healthcare licensee who is allowed to practice is probably the most dangerous person out there, and even a moment of impairment can cause irreparable harm to a patient. However, no healthcare licensing board had established meaningful rules or standards to govern the handling of substance abusing licensees. For its part, this board had a diversion program that diverted substance abusing physicians away from the disciplinary track and into a monitoring program that failed 5 performance reviews during its 27-year history. And this board unanimously voted to abolish that program in July of 2007. Other boards had diversion programs, and the administration of which were outsourced to a private for-profit corporation. Some boards don't have diversion programs at all. They attempt to deal with substance abusing licensees via their enforcement process, which is public. But there were no consistent or uniform standards or rules to which participants in these programs or the staff of these programs were held. And that didn't make any sense to Senator Ridley Thomas. He didn't care whether you were an MD or an osteopathic physician or a pharmacist or a nurse. If you're a substance abusing licensee and you're allowed to practice, you can kill someone. And you should not be treated differently based upon which board has given you a license. So he drafted SB 1441, which was passed and signed in 2008. And as Dr. Levine said, it required the Department of Consumer Affairs to set up this Substance Abuse Coordination Committee to fashion uniform and specific standards in 16 specified areas, which, and I quote from Business and Professions Code Section 315, each healing arts board shall use in dealing with substance abusing licensees, whether or not a board chooses to have a formal diversion program. So the uniform standards were finalized in April of 2011. They look like this. They're on the department's website. There's 29 pages of them. And your job now is to adopt a regulation that requires you to use these in cases involving substance abuse without deviation. Your staff has chosen to take 29 pages of uniform standards and collapse them into 8 pages of regulation that renumbers and reorders and paraphrases the uniform standards. And as I've said on a couple of occasions, that's not wrong. It just makes it a little more difficult to determine whether everything that's in here has found its way into your proposed regulation. And you'll recall that you looked at some draft language in July, at your July meeting, and I told you about 5 or 6 rather glaring omissions. And in September, that July language was published without change. But as Ms. Webb stated, in October, some revisions have been published, which you now have, which include most of the omissions that I mentioned in July. And thanks to your staff for doing that. Thanks to you and your staff for doing that. But on closer inspection, I have found 12 additional omissions or inconsistencies, and I have detailed them for you in written testimony dated October 22. I think that my testimony is fairly self-explanatory. It's quite detailed. There are significant detail from Uniform Standard Number 4 regarding drug testing, Uniform Standard Number 5 regarding group support meetings, 6 regarding treatment is missing entirely from your regulation. There are omissions from Uniform Standard Number 7 regarding worksite monitors and the duty of those worksite monitors to report relapses to you. This is very important. Uniform Standard Number 10, which in my view contains mandatory consequences for major violations, has been converted into a discretionary regulation, which is wrong.
Ms. Felmuth, I have to
yes.
ask you to please wrap up.
Thank you, I will. The bottom line here is that everything in the uniform standards that is applicable to a board without a diversion program like you needs to find its way into that regulation. In terms of the 6 criteria that Dr. Levine mentioned, you are not authorized to deviate from these. That's the authority issue. And on the consistency issue, your regulation has to be consistent with these. Thank you very much for your attention. Appreciate it.
Thank you, Julie, and thank you for the detailed comments you provided. As you said, they are clear and self-explanatory.
Thank you, Dr.
Appreciate them. Next, Yvonne Chung from the California Medical Association.
Good morning. My name is Yvonne Chung. I'm representing the California Medical Association. We submitted written comments as well. I'm not going to go into the detail of the specific recommendations that we made. I just wanted to give some general comments. Our comments largely go towards clarification. We understand the need for promulgating these regulations. However, there are certain aspects of the proposed amendments that we believe need further clarification in order for a physician to properly comply with those and for the board to appropriately enforce those provisions. And those are detailed in our letter. While we recognize that the board has been directed by the Department of Consumer Affairs to promulgate regulations to implement these standards, we would note that the SB 1441 standards were not adopted pursuant to a standard regulatory process. They are not regulations. The board is vested with independent authority to promulgate and adopt regulations that serve to strengthen the Medical Practice Act. So we wanted to remind the board of their independent authority and responsibility to evaluate these proposed regulatory amendments to ensure that they are really appropriate in the context of existing law and practice. And in some cases, we applaud the board's effort to try and look at what the standards require and how they actually fit into what makes sense for physicians. There are aspects of it, for example, in what one of the amendments refers to monitoring by a licensee of the same scope. Well, the licensee of the same scope for a physician is a physician. So there are points like that where we feel like it just needs to be a little bit more clear what it is that the board is trying to do. And I understand that it's hard to match it directly with the standards. And looking at how physicians actually practice, what makes sense, and how these regulations can be most effective. Thank you.
Thank you, and again, thank you for your well-considered comments, written comments. Next, Michelle Montserrat Ramos.
Good morning, board members. My name is Michelle Montserrat Ramos, and I'm with Consumers Union, California Safe Patient Network. We support as long as the suggested amendments are included, specifically that the full uniform standards are incorporated into regulations. As you know, I've spoken before you many times throughout the past 5 years on the need to follow the law and implement the full uniform standards as SB 4041 requires. As I said at the July meeting in Sacramento, I cannot believe that's 5 years later and I'm still here speaking before you to implement the full uniform standards. Maybe I need to take a step back and remind you that people have died here. I speak for California consumers and I advocate on behalf of a specific person. His name was Lloyd Montserrat. He was 36 years old when he died. His surgeon chose crack cocaine over his own personal welfare and the welfare of his patients. There's others of the same opinion. The Legislative Council Bureau, the Office of the Attorney General, and the Department of Consumer Affairs each issued opinions unequivocally stating that the finalized SB 1441 uniform standards are mandatory. They must be used by the healing arts boards in dealing with substance abusing professionals. We were under the impression that the board had recently finally agreed to comply with the law in full and adopt all the uniform standards. However, the board's amended proposed regulations of October 25th, 2013 are rife with omissions. They clearly do not reflect uniform standards as required by law. SB 1441 was explicit that the uniform standards must be adopted regardless of whether or not a board has a diversion program. The fact that the medical board does not have a diversion program is not an excuse for failure to adopt any of the uniform standards. The board should amend the current proposed regulations to include all elements of the uniform standards as required by law. Some of the important elements of the uniform standards that have not been included in the current draft regulations include uniform standard number 4. You failed to specify the requirement for random drug testing of first year probation and failed to include requirements of public reporting regarding physicians who tested positive for a banned substance, failed to appear or call in for testing on more than 3 occasions, failed to pay testing costs, or a person who was given a dilute or invalid specimen, and 16 other data requirements. There's data missing from uniform standard number 10, uniform standard number 12, uniform standard number 13, uniform standard number 14, uniform standard number 15, and uniform standard number 16, where you failed to adopt the important reporting requirement, which requires an annual report to the legislature and the Department of Consumer Affairs. You know the legislature sent you a letter with a long to-do list of tasks you need to fulfill to show that you're meeting your mission of protecting the public. Well, implementing the full uniform standards was on that list. Again, we're asking you, please follow the law and amend the regulations to include the full uniform standards. Thank you.
Thank you very much. Geneviève Claverel.
I am going to pass.
Okay. Are there any members of the public who would like to comment? Hearing none, this hearing concerning the implementation of SB 1441 is closed now. And as I think everyone can appreciate, due to the numerous comments received and the timing of their receipt, I'm going to recommend that the board direct staff to prepare a summary of each of the comments and provide a response to the comments. The summary and recommendations will be considered at our next board meeting. I also recommend that staff be directed to redraft amended language for the proposed regulation that incorporates both the changes that staff recommends be accepted and also the meritorious suggestions offered by those who have provided comment both in writing and verbally today. Clearly, this is a piece of work, and edits are going to be necessary. Staff will need time to analyze the comments and provide the board with recommendations. The new language will come back before the board at our next meeting for review and approval, and with the board's approval, the new language will be posted for a 15-day comment period. If no new negative comments are received, then the proposed regulation will move forward in the rulemaking process. If we do receive negative comments, the board will have an interim meeting next spring to consider the comments and determine proposed amendments. So we are determined to move this process forward.
I'd like to make that motion.
I'll second it.
Any questions from the board members? Mr. Serrano-Sewell.
That's clearly the best way to proceed. And do you, Dr. Levine, do you contemplate in staff's the document that they're going to prepare for our February meeting, right? Okay. That will be will their commentary also include? It will include all items that have been brought up, because there were some that, and as I understood the staff report as it stands now, did not include, or certain standards were not included because I'm speaking with reference to Uniform Standard 13 and those that deal with the vendor. And I understand the policy rationale for that, but will their comments, these revised comments, include further elaboration and perhaps proposed language that could be included in our final adoption?
There will be a response to every comment, and then proposed amended language to incorporate the regulatory language that staff is going to propose based on clearly a lot of the comments that have been raised. So what we will see, every comment made will be addressed with a response, and we will have revised language to consider.
So thank you, but if the response is, we don't think this standard should be included, that will be the end of it. There would be no proposed text, or would there be? Do you know, can you?
It's never the end of it if there are negative comments.
Okay, so there could be some proposed text.
Mm-hmm.
Okay, thank you.
I have a question.
Yes, Jamie. Ms. Wright?
Will the staff report also include how, and I mean, this may not even be relevant, but how it will affect the transition of, how it will affect the board with the transition of staff to the Department of Consumer Affairs? I'm just trying to understand what the staff report's going to include and how that'll impact the board.
The movement of the investigators is, I think, correct me if I'm wrong, I'm out here on a limb, I'm interpreting, but I don't think that impacts how we manage our probationers.
Okay, that's.
Which is real, yeah.
Okay.
Our probation monitoring unit actually will remain at the board.
That will remain?
Yes.
So that will not affect, okay.
Thank you. Any comments from members of the public before we vote on Mr. Serrano-Sewell's motion? Seeing none, all in favor?
Aye.
Opposed? Any abstentions? Thank you very much. And thank you again to those of you who spent a lot of time in providing us with thoughtful comments. Moving on to our next agenda item, Ms. Christine Lally from the Department of Consumer Affairs. We're on agenda item number 24, which is an update from the Department of Consumer Affairs.
Good morning, President Levine, members. Pleasure to be here with you the past 3 days. You have a lot of stamina. Again, my name is Christine Lally. I'm the Deputy Director for Board and Bureau Relations with the Department of Consumer Affairs. And in this capacity, I have the pleasure of working very closely with your board president and your interim EO, Ms. Kirchmeier, as well as all of the boards and bureaus under the DCA umbrella. I know you have a full agenda today, so I'll make my comments brief. But on behalf of DCA Director Denise Brown, I wanted to applaud the board, Ms. Kirchmeier, and board staff for your leadership and partnership to implement the BRAZE project in SB 304. Both remind me of a quote that I have up in my office that I refer to at least 3 to 4 times a day, and that quote is, it's not going, excuse me, it's not going to be easy, but it's going to be worth it. And I think that we both can agree, or we all can agree, that BREEZE and SB 304 are not small tasks by any stretch of the imagination, but working together, we can both make them worth it. So again, just want to highlight and acknowledge your immense investment in both projects. And I know it's been, especially on BREEZE, it's been a strain on your board staff. And in preparing for this meeting on SB 304, they've been just nothing but gracious and helpful. So deepest, sincerest thanks to the board and all of you for the hard work that you do. So thank you. And then also I wanted to highlight, especially for the newest members to the board, and welcome, that in these final months of 2013, we do have, I wanted to give a little refresher to the other members as well, the required training and forms that are your responsibility as board members. So California law requires DCA board members to complete board member orientation, ethics training, sexual harassment prevention training, and of course, I think our favorite, the Form 700, the Statement of Economic Interests. For the newest members, we have a board member orientation training coming up in November in Sacramento, and that's a one-day training at our Solid Training Center, November 20th. And I'm happy to shoot you those details to get you on board. If you can't make that, we do have some tentative dates in 2014 that hopefully can accommodate your schedule. April 2nd, tentatively scheduled in Sacramento, and then June 24th in Southern California. And you're required to take that member orientation training within 1 year of assuming office. Then next, the ethics training. Appointees are required to take an ethics training course within the first 6 months of assuming office, and you need to repeat this training every 2 years throughout your term. This is online training, so you can take this at your convenience, and I will shoot that link again to Ms. Kirchmeier, and she can share it with the board. And make sure that you make a copy of your certificate after the training and get credit for it. Then third, the sexual harassment prevention training. Appointees are required to attend this interactive training every 2 years. However, 2013 is a required mandatory training year. So even if you've taken it last year, you have to take it again this year. Surprise. So we offer this training through the department, and it's can be in the classroom setting or also as a webinar. And we have a few dates coming up here soon. November 7th, we have 2 classroom trainings, and again, those are at our Solid Training Center at the department in Sacramento. And then also we have 2 webinars coming up, November 20th and December 17th. And again, I'll share that information again with Kim, and she can share it with you. And then finally, a reminder on the Form 700, which is extremely important to all appointees. After your appointment for the new members, you should receive a packet of information from the department, and that includes your Form 700. You're required to complete this form within the first 30 days of your appointment. And then, of course, you have your Form 700 annual statement that's due same month as your taxes, but a little earlier, April 1st of each year. And then often in an area that tends to get overlooked, and we have to remind folks, is when you leave office, when your appointment finishes, it's very important to complete the Form 700 leaving office statement, and that, again, like when you start, needs to be completed within the first 30 days after you leave office. If you ever have any questions on any of the required training or what's required of you, please do not hesitate to reach out to me. Kim has my information, as well as Dr. Levine. So definitely here as a resource. We have some board member resource information on our website, an actual website dedicated for board members, and that's dcaboardmembers.ca.gov. And that gives you a brief overview of all the required trainings and upcoming dates and other information that you might find valuable. So please don't be a stranger, and I won't be as well.
And I want to thank you for the work you've done to keep us apprised of what's going on at other boards.
I'm trying to keep up with you, Madam Madam President. Thank you. I appreciate that very much. I joined the DCA team in July, and it has been a learning curve getting up to speed with all the boards, and I very much enjoyed learning and working with you.
Same here. Was this a new role that you took?
I did, yeah. I was at a previous
No, I mean, is the role new?
This job, no, sorry. No, there was another person in the job.
Well, you're doing a great job.
Thank you.
Thank you in supporting us.
I appreciate that.
Any questions or comments from board members? Any questions from or comments from members of the public? If not, thank you again for coming to Riverside and spending 3 days with us. We are now on. And I think I'm going to ask now for Ms. Yaroslavsky. This is agenda item 18 from yesterday, which is an update on the Health Professions Education Trust Fund. Foundation. I knew it was an F.
It's okay, I know what it's okay. Thank you, Madam President. I would like to first take a moment and introduce a member of the Health Professions Educational Foundation Board who has joined us this morning for our medical board meeting, who lives in the Inland Empire here. And I'd like to ask Mary Helen Ibarra to please stand up for a minute, and thank you for being here. Mary Helen is almost as busy as I am, I think, serving on so many different community boards and engagement in the community. I want to thank her for her service at HPF. She's going to be a remarkable resource. But in addition to that, she also serves on the Corona Fire Safety Committee, the Greater Corona Hispanic Chamber of Commerce, the Corona Norco PTA Council, Community Affairs, and her list continues to go on and on and on. But she has also received numerous awards from the Riverside San Bernardino community, one in which was she was recognized as the 71st Assembly District Woman of the Year at the State Capitol for extensive volunteer and advocacy work through the district the past 25 years. And she's also received a certificate of congressional honor from the Honorable Ken Clavert, 44th Congressional District. She's also friends and very good friends with many elected officials here in the Inland Empire, and I would venture to say that we should take advantage of that relationship building in the future. So thank you very much. So now as to my report on the, I'm going to give you a health professions report, correct? Okay. We've had a very exciting year at HPEF. We've had a number of programmatic and fiscal changes. Specifically, the application cycle for the 2013-14 was extended to October 25th of 13, allowing applicants to submit their scholarship and loan repayment information electronically for the first time using the responsive electronic application for California's healthcare, which is we call CalReach, which is an electronic online application format, which has really worked well and saved us a lot of time. Cost us a fraction of what your BREEZE program costs, you should know. It works. We have an application for a $14 million grant from the California Endowment, which we've received, and it will include a provision to award a minimum of 65 allopathic and osteopathic primary care physicians and physicians, in the year of 2013-14. We're very excited about that. We were also awarded a one-time award from the Assembly Committee of Rules for $2 million. We've got an authority to spend another $2 million plus for the mental health loan assumption program, which was left over from previous years. In addition to the community health workers and medical assistants as eligible professions, we've put them into the Allied Health Scholarship and Loan Repayment Program. The passage of AB 565 has added primary care physician-owned and operated medical practices as an eligible practice setting for the Stephen Thompson loan repayment. So that's something that we need to make sure we get out to our physicians. The passage of SB 21 is the establishment of the University of California UC Riverside Medical School, and it's going to, in conjunction with the health facilities of its medical residency program, it's going to assist their medical students to be eligible for our physician retention program, but including also the Stephen Thompson loan repayment program. So also we have the investment of the Mental Health Wellness Act of 2013 has been chaptered, and it's going to restore the administrative fund percentage from the current 3.5 voter-approved proposition to 5%, so which will help key regional concerns which have statewide significance. And the passage of SB 271, the Associate Degree of Nursing Scholarship Program, has been chaptered, and in exchange for up to $10,000 in financial aid, the Associate Degree of Nursing students will provide direct patient care in medically underserved communities in the state of California. It also eliminated the January 2014 sunset date of this program, so that's going to go on indefinitely. So we've been doing a lot of new things. Our laws are helping to engender more participation statewide, but we also have a new executive team in place. We have a new executive director. Her name is Jeanette Torres, and she it just came to us in the last couple of weeks, and Karen Eisenhower, who many of us know, will be returned to her job of the Senior Director of Programming, along with Judith Melson. So thank you very much. We're all very excited. We've got money to spend. We need programs out there and people to apply. So thank you very much for this time.
Thank you. I can't imagine a better marketing person for this program than you, Ms. Jaroslavsky.
Thank you. I'm trying.
Yes.
Thank you, Ms. Jaroslavsky. It's really good to hear that we did get a $14 million grant.
Yes.
One area which we haven't looked, I think maybe you should consider is how can we support increasing the number of primary care residencies in California? I remember that the biggest bottleneck in primary care in California is not medical school seats, it's the residency programs. And also when people do their residency in in an area, there is about 40 to 60% chance of them going into practice in that area, especially primary care. So I think that's a very important thing. If there is any way if we are allowed by law to look into that, those programs, I would truly appreciate it.
Be happy to talk to anyone I can.
And at our February meeting, Catherine Nation from the President's Office at UC is going to come and speak to the issue that Dr. Nuovo raised about the bottleneck, if you will, in terms of the gap between the number of medical school graduates that are graduated each year and the available number of residency programs in the country. And so she's going to be coming to talk to us in February about that. We identified that as a critical issue. Any other comments from board members? Any comments from members of the public on Ms. Yaroslavsky's report? Seeing none, we're going to move on to agenda item number 26. We're going to ask Ms. Harold and Ms. Kirkmeyer.
We've done that.
Oh, 27, sorry. Update on the prescribing task force. I got the right people, the wrong number.
That's me again.
Oh, sorry.
It's okay.
And Dr. Bishop.
So I'm going to read the report on behalf of Dr. Bishop and myself. I want to thank the staff of both the Board of Pharmacy and the Medical Board for having put on a most interesting day for me personally, and I would assume as well for Dr. Bishop. I would like members to turn to their packets to item number 27 and realize that on September 23rd, the prescribing task force met for a full day to discuss the communication between prescribers and dispensers. The meeting was well attended and had representatives from not only the prescribing and dispensing communities, but also law enforcement, consumer groups, other regulatory boards and associations, other state agencies, and ledge staff as well from some of the larger, and we had representation from some of the larger pharmacy chains and pharmaceutical companies. We had probably 80 people that participated in this all-day conference. Much of the discussion focused on the identifying appropriate patient information that can be shared or discussed between the prescriber and the pharmacist. A presentation was made by our own Laura Sweet on how pain management has evolved and the physician's responsibility in prescribing. Deputy Attorney General Joshua Room provided information on a recent decision adopted as presidential by the Board of Pharmacy regarding the pharmacist's corresponding responsibility in ensuring appropriate prescribing. The attendees formed small groups and engaged in robust discussion regarding the information that could be and should be shared. It is encouraging to note that the prescribers and dispensers in the room were not all that far apart in the information that they felt should be shared. Topics they agreed on included diagnosis, information regarding the patient's treatment plan, validation of the information on the prescription, reasons for unusual prescribing, and pain management contracts. Education to prescribers and dispensers regarding their roles and responsibilities, HIPAA and red flags, all well as education of consumers and enhanced cure systems were all identified as solutions that would assist in curbing overprescribing. The task force will be meeting with other regulatory boards to develop a document for prescribers that can provide guidance on information that can be shared and other educational tips. The task force will be scheduling a meeting between now and the February board meeting to discuss current pain management guidelines and also focus on best practices for prescribing. I'd like to point out that the presentation by Laura Sweet on the evolution of the pain management situation was very well received. The board received numerous requests for this PowerPoint presentation and has been placed on the board's website. If any member would like to have this presentation done in any venue, please contact our Renee Threadgill. Thank you very much.
Thank you, Ms. Yaroslavsky.
Dr. Bishop, I don't know if you have anything to add, but please.
It seemed at times to be chaotic, but I think that's the way a lot of decisions are made. But in the long run, it really was rewarding, and I think everybody left there feeling good about what had been done. So I think it was a very, very good experience for all. I look forward to more meetings and getting further along the track.
Absolutely, thank you.
So is a crowdsourced solutions.
Absolutely.
Terrific. Any questions for Ms. Yaroslavsky or Dr. Bishop from members of the board? Dr. Gananadev.
Still, the system in Cures database to log in to sign up is just still a complete disaster. So I'm just wondering, when is that going to be taken care of?
I'm sorry.
The Cures database?
Cures database,
is it
it's
funding?
actually, you can't sign up, you can't log in, it's so.
So you can't use it?
Yeah, it's just, it's so complicated and it has so backed up, so that's why I'm just wondering.
I think the
when
problem has
can it
been,
be?
I think Ms. Kirchmeier will probably address this, but I think there's been an issue of funding and staffing, that one person, one afternoon does it. And that's my understanding, that's a.
One heroic Maytag repairman.
One fantastic
but
human
it's his
being.
Full-time job.
Works one
The
afternoon.
good news is that SB 809 passed. We now have a funding source to actually upgrade the Cures system, and Ms. Kirkmeyer has probably more detail on that.
In addition to the passage of SB 809, as you may remember from the last meeting, there was funding in the Budget Bill Act that passed that required the board to put forward $1.6 million for the CARES program as well, even prior to the additional fees to the physicians. Where that is right now is the Department of Justice is working on a feasibility study report. And they've asked the department to assist them. And I know Ms. Harold and Ms. Lawley and all of the team there have been instrumental in meeting and putting forth requirements. I know right now we've submitted those, I believe, to the Department of Justice, so they know what the boards need. And it's supposed to be, I believe, over the next 2 years then, them implementing the system. So I would think probably 2 years out. Ms. Harold, you agree? That's probably... Yeah, we don't know, but that's kind of where the funding is for those 2 years.
The intent is to build and to buy. That was the budget appropriation that occurred with this year's budget, was really to buy a new computer for the Cures system, because the existing one was developed in the mid-1990s, and it doesn't have the interface to permit the access of practitioners at the level that they need to have. So they're upgrading the system, and I believe their intent is to house it completely within the Department of Justice so that there isn't an outside vendor, as there is now, that cleans the data from those that dispense. That is an unnecessary step today, and pharmacies and practitioners that are dispensing need to be able to put in clean enough data that it's usable into the system. But I think one of the things I was going to say, and I had enough time up here at the mic earlier, and look at me back here now. The concern that we have is the system is going too slow. And we're concerned, not only is there only one heroic individual that's doing it part of the time, but we're spending a lot of time going out and trying to encourage our practitioners to sign up, and they're met with nothing but frustration, which further eviscerates, really, the whole need of Cures and getting people predisposed towards using it. So the actual funding bill, or in SB 809, there's a requirement that as part of your renewal of your license, you're going to be signing up to access Cures. Hopefully the system's there, but we're not quite sure what's going on in the Department of Justice. And now that we're in a stage where we're past the end of the legislative year, the department has already started inquiries on behalf of the boards, because in particular this board and our board, and perhaps if anything our board maybe even a little more so than your board, is very interested in Cures because it literally drives our enforcement program.
So let me ask you a question regarding that. Is there any collaboration with all of the boards that are would be in a prescribing position?
Yes.
To be involved?
They all were participating through the department's auspices. They coordinated this, and it must have been May or June. We finished the parameters for the system. We're waiting now for the Department of Justice to review through those, and it was very detailed.
Is part of your interface to be some kind of electronic medical records that will be accessible on a broad, I mean, is it going to be available to be used and the computers will talk to each other in the end?
I don't know how the medical record, the electronic medical record, would actually feed into the Cures system. It would be the dispensing that triggers it, not the prescribing.
Okay.
I hope there's an intent to include a users group in terms of system needs. I mean, I think one of the experiences we've had collectively as a country is when the end users are not involved in providing input into the design features of the system, it doesn't work. And this is so important that I really hope the Department of Justice has a mechanism for involving frontline pharmacists and practicing physicians.
We believe that that's part of the system, and part of it by having co-governance over the system, which was part of the Budget Act appropriation, that we got co-governance. In the past, basically it was a Department of Justice run program, which was relatively frustrating to regulatory boards.
And another thing we did too is when we had all the meetings together, of which Ms. Katie was a real instrumental in bringing issues from the board and from our perspective, was we were all looking also what also does the provider need out there in the field. But we couldn't agree more with you that it needs to be tested by the individuals who are going to be using it. We're hoping for that. We do have co-responsibility a little bit with them, but as you know, that we're still waiting to hear back from them at this point on that.
But the danger is, and it's time for us to start revving up a little bit, but the department, and keep in mind this is an IT project, so it's got to go through the same folks generally that are implementing Breeze, because that's where the main focus of this is. We are now 18 months away from the July 1 date, and just procuring a computer system in 18 months is a difficult process. So it already looks to me, I like to worry, but it already looks to me like we're starting to lose that July 1, 2016 date, which is what we all were focused on.
Great, thank you very much. Dr. Gananadev?
Yeah, this was somewhat like an ARFUN system which was being managed by the Department of Justice. My curiosity is, why not look into legislature to transfer it to Department of Consumer Affairs, where all the boards are? I mean, this is just like Breeze. I think it should be in a place where the boards have a constant communication how to handle these issues.
Personally, I think the boards believe you, would agree with you. The Attorney General, however, wanted to keep the program where it is.
Thank you very much. Any other board members have questions? If not, I have one slip from member of the public, Geneviève Claverel.
Good morning, Geneviève Claverel. I'm sorry I could not attend that meeting when my daughter was in a hospital losing a kidney, but I am very concerned of what I'm hearing. Because, you know, a couple of times I presented to you and to some of your members and sent the information about the Oklahoma system of what's called PMP, Prescription Monitoring Program, with up to the minute enabled to tracking prescriptions. And, you know, when you try to do a computer system and so on, it's always much more easy when you look at something that already works. And I will have highly, emphasized that. After all, we are in California, where we have a lot of technology. I think myself, I will ask JPL, Caltech, to help me, to do it even as a pro bono job. It's obvious the cure program is defective. It's an old dinosaur, and to make any correction to make it adequate is not going to happen. And that's what's happened a lot in technology when you have something which is not working well and not made to handle the number of input is not going to receive. So I think maybe, I don't know if you read the article yesterday about that group called Script Check and who is owned by Quest Diagnostic. They are able to monitor any individual in California or anywhere who buy any kind of prescription, even on cash basis. They are able to identify even the disease those people have. because that's insurance, big money. So maybe you could invite them to a round table and see how they are able to do that tracking. I mean, what you need is a super sophisticated software system, and Cure is not it. And I don't care how much money you're going to put on it, it's not going to happen. And let me tell you, I was very involved in HIV and AIDS in 1981, before, Gore invented the internet, but, we had 15,000 universities connected. So that's possible. But you need to have not only the equipment, but specifically the software to do it. And Cure is not this, it's not this. I mean, I have looked at it, and I don't care how much money you're going to put at it, it's not going to work. But I will really appreciate that some of you look at the Oklahoma system. And like I said, I don't have no connection with Oklahoma, but I'm a person who's very nosy, and when I'm trying to solve a problem, I already look at what works, not what does not work.
Thank you very much. Any other members of the public? All right, thank you. And thanks very much to Dr. Bishop and Ms. Yaroslavsky for their work in this. We're going to move on now to agenda item 28, the Midwifery Advisory Council. Ms. Sparavon.
Good morning. I'm Carrie Sparavon. I'm the chair of the Midwifery Advisory Council to this board. Welcome. I haven't reported to you since January for scheduling reasons, I think. Heavy schedules on your end. As I think most of you are aware, but maybe not all of you, and since Ms. Simoes has not given her report yet, I'd just like to thank all of you for your support of AB 1308 as it was amended. It removed physician supervision from the requirement of licensed midwives, which will, I believe, ultimately open the door for more workable consulting arrangements between licensed midwives and physicians. And of course, this will create greater consumer safety and options for women in our state. Additionally, 1308 will enable licensed midwives to legally obtain the medications, supplies, lab tests that they need to safely care for the women that they serve in an out-of-hospital setting. I'll let Ms. Simoes give you the rest of the report on AB 1308. Tosi Marceline, who's a licensed midwife, was approved by the Midwifery Advisory Council to be the new licensed midwife on our on that council, and I would request your approval of her appointment. I think she's a wonderful choice. She was instrumental in getting the original legislation approved.
So, per Ms. Sparavon's request, can I have a motion to appoint Ms. Marceline as a member of the Midwifery Advisory Council?
I so move.
Thank you, Dr. Lewis, Dr. Krause. Any board member questions for Ms. Sparavon? And congratulations, that was a long, hard road to get that bill passed.
It was indeed, and I was as surprised as probably anybody that we were finally successful in making that law really work for the citizens of California, and I am pleased as punch.
Any questions? Any comments from members of the public on Ms. Sparavon's report? Seeing none, thank you again.
Okay, I need to ask you for
we have to
agenda
vote.
Items, yes, and you have to vote on Ms.
We have to vote on
Marcelino.
the motion. Thank you. All in favor?
Aye. Aye.
Any opposed? Any abstentions? Thank you. Go ahead.
Okay, so we have an upcoming meeting, I believe the 6th of December. I might be wrong, might be the 8th. I'd like to request that we put in addition to the normal items that we have on our agenda, kind of the ongoing things, I'd like to appoint a task force to discuss development of an information packet for new board members regarding licensed midwives, something that would be brief enough to get through, but informative enough to allow new members of the board to kind of understand the issues that licensed midwives face in this state. I'd like to also entertain the idea of creating task forces that are necessary to implement AB 1308. And we're expecting a report at the next MAC meeting by Ms. Simoes and legal on what those particular issues might be and how we can interface with that. We need a task force to address possible changes in the data collection set to bring it in line with nationally collected data points as dictated by AB 1308. I'd also like staff to give a brief report on what are the issues surrounding patient abandonment and how does that work for licensed midwives, particularly around, there's some elements now in AB 1308 that will absolutely dictate transfers of care. And I think licensed midwives, one of the big questions that I'm hearing is, what about patient abandonment? How much time do we have to transfer? What kind of notice do we have to give them? In addition to what needs to put in the initial informed consent that they receive. So it'd be really helpful to have staff, particularly legal, update us on that. And then we need to continue discussion and task force surrounding assistance to licensed midwives, because in many areas of the state, it's not possible to have two licensed personnel or even a licensed midwife and a student who's enrolled go to births. And so assistants are a really, really important factor in keeping women safe at home. As you can imagine, if you have a baby that needs resuscitation and a mother that's bleeding, you kind of need two sets of hands at the minimum. And so we really need to figure out what needs to happen going forward to create assistance for licensed midwives. And that's all I have. Thank you very much.
Thank you.
So she needs permission.
Yeah, I
for the
need
agenda,
permission
so
to put
she
those
needs
things on the
We need
agenda.
a motion.
Oh.
So I'll make the motion to allow. So I want to just preface my remarks for board members who might not be aware that the Midwifery Advisory Council operates under the auspices of the Medical Board. I sit on that committee. Our agenda and anything we do has to come through this vehicle, the board, in order to be approved. So we can start the meeting and then continue with the meeting. So to that end, I would like to support Ms. Sparivon's request for the ability to appoint a task force to deal with legislation, clarification, and implementation. That I want to thank the medical board staff and the long history we've had here of trying to elevate this to a level where we have some real positive shared goals. So thank you. So I would like to make that motion and ask for a second.
So you're moving all the agenda items?
The agenda items that she needs.
Ms. Sparivon put forward.
And Dr. Yip seconds it. Thank you, Dr. Yip.
All in favor? Oh, sorry, public comment. Whoop. Board member questions. I forgot to ask the board. All in favor?
Aye.
Aye. Any opposed? Any abstentions?
Thank you very much for your continued support.
Hello, Karen Ehrlich, Vice Chair of the Midwifery Advisory Council. You have heard how many issues we have to deal with in the next, hopefully not too long. When the council was first empaneled and begun in 2007, we were authorized to have 4 meetings a year. There was a great deal of work to be done at that time, and we really used all 4 meetings a year and needed them to get that work done. Things slowed down some, and then there were staffing issues on the medical board. And we have now pretty much gone down to 3 meetings a year. I would like the board and staff to consider, while we are trying to implement this new law, that we move back to having 4 meetings a year. I think we have more than enough work to fill all of those meetings in order to move us forward. Thank you.
Thank you. Okay, I'm going to move on now to agenda item 29, Ms. Simoes, who's going to walk through legislation and regulation with us.
Good morning,
She's brought
members.
a document the size of a phone book with her.
It's just 2 packets.
2 phone books.
First, I would like to report that I've contacted legislative offices in the Riverside area, but unfortunately, they're unable to attend our meeting today. As was introduced yesterday, as far as legislative staff, we do have a legislative staff member that Dr. Levine introduced yesterday, Taryn Smith from the Senate Office of Research. We did invite our other legislative staff, like BMP members, like we do every time, but the legislature is also under some travel restrictions like state employees are, so they were unable to attend. The 2013 legislative session has ended, and the legislature does not reconvene until January 6, 2014. The governor has taken action on all bills that we have taken positions on. For bills that did not pass the legislature this year, this is the first year of a 2-year session, so the bills have 1 more year to pass the legislature. Please refer to your legislative packets. Your tracker list is found after the cover in your legislative packet or under item 29A, NBC 2013 tracker list in your electronic packet. The bills in pink were signed into law by the governor. The one bill in orange was vetoed by the governor, and the bills in blue are all 2-year bills. We will be discussing the bills in pink and orange today. A little bit different from other meetings, I'll only be giving a brief summary of each bill and then discussing the board's implementation plan. To kind of start this off, every year in our newsletter, in our winter newsletter, we include summaries of each bill that passed the legislature, not only ones that we've taken positions on, but also on bills that maybe are on our tracker 2 list, but they impact physicians. And so instead of, for my implementation plan for each bill reading, we're going to do an article in the newsletter. Just so you know, every bill we're going to do an article in the newsletter. So I don't want to read it for each bill, but know that every bill that we're going to talk about today, we will have an article in the newsletter on. Okay.
In the
so
same newsletter or in a different each?
In our newsletter.
I was asking one article for all the bills or each
no,
quarterly?
We do a little summary on each bill, so the physician knows how it's going to impact them. Well, the new members don't know that, though. Okay, so let's start the first bill, AB 154 Atkins. This bill allows physician assistants, nurse practitioners, and certified nurse midwives to perform an abortion by medication or aspiration techniques in the first trimester of pregnancy. And what we'll do for this one is notify trained board staff of this bill's passage. Does anyone have any questions? Okay, I'm going to move to the next bill. AB 512 Rendon extends the sunset date in existing law from 2014 to 2018 for provisions that authorize healthcare practitioners who are licensed or certified in other states to provide healthcare services on a voluntary basis to uninsured or underinsured individuals in California at sponsored free healthcare events. The board's implementation plan is to notify board staff of the sunset extension and to ensure that the board will continue to process requests for authorizations from physicians licensed in other states until 2018.
Is there a way that you could make sure the FSMB would maybe put some kind of a small blurb in their newsletter? I mean, this is, I think, impacts not only California, but other physicians around the country who might be willing to come to California, so.
Yeah, definitely. We have contacts at FSMB and we can forward that information to them.
Thank you.
Okay, the next bill is Ms. Yaroslavsky briefly mentioned, AB 565 Salis. This bill strengthens the guidelines for selection of applicants to the Stephen M. Thompson Physician Corps Loan Repayment Program and expands on the definition of practice settings for this program, as Ms. Yaroslavsky mentioned. And for this one, we're really just going to include an article in the newsletter. If there's no questions, I'll just go to the next one. AB 635 Amiano allows healthcare providers to prescribe, dispense, and issue standing orders for an opioid antagonist to persons at risk of overdose or their family member, friend, or other person in a position to assist persons at risk without making them professionally, civilly, or criminally liable. It also extends the same liability protection to individuals assisting in dispensing, distributing, or administering the opioid antagonist during an overdose. And really, this one, we're just going to notify trained board staff. Next bill, AB 1000 Wachowski. This is the bill that allows patients to directly access physical therapy services and also allows physicians to employ a physical therapist. And this one, again, we're going to notify trained board staff of this new law. Moving on, AB 1288 Perez. This bill requires the board to develop a process to give priority review status to the application of an applicant who can demonstrate that he or she intends to practice in a medically underserved area or population. For this one, we will notify trained board staff, and we also have to develop a process for priority review status and revise the licensing application. And we're going to also work on informing postgraduate training programs.
So just as a matter of personal interest in this, how is it that if we are doing so well in licensing, that we're doing really an excellent job, our staff has been really amazing, how are you going to prioritize, how can you possibly prioritize, nobody's waiting?
We are meeting this now, and so this would take place in a time maybe when we're not doing as well as we are now.
Okay.
Because we are, basically every application is given priority
everybody,
review status, and what happens a lot of the time is we review it, but we're reviewing it so fast we don't have the document, everything that we need from the applicant. So this would be, maybe take more precedence in times when we're not doing so well. And CMA's here, they could talk, this is their sponsor bill, so they can maybe talk a little bit more if you have questions.
Thank you.
Okay, any other? Okay, I'll move on to AB 1308, and Ms. Barravon did talk about this a little bit in her presentation, so you kind of know, oh, sorry.
It says support if amended. So what was the amendment we did, and was it taken?
AB 1308?
Yes.
Actually, sorry, that should say support. At one time, we were support if amended, and we wanted the physician supervision issue to be fixed. It did get fixed, so at the end, we did issue a letter of support, and I went and testified in support because that was our amendment that we had requested. Okay, so as Ms. Barravon mentioned, this bill removes this physician supervision requirement for licensed midwives and requires licensed midwives to only accept clients that meet the criteria for normal pregnancy and childbirth. It also authorizes licensed midwives to directly obtain supplies and devices, obtain and administer drugs and diagnostic tests, order testing, and receive reports that are necessary to the practice of midwifery, among other provisions. The board's implementation plan for this is to notify licensed midwives via letter of the changes to law, to notify trained board staff, to update the board's website with changes to the law, to work with interested parties and stakeholders to develop regulations specifying any pre-existing maternal disease or condition likely to affect the pregnancy, and any other regulations that we find later that we need to implement this bill. We'll need to develop processes and procedures for hospital reporting of each transfer of a planned out-of-hospital birth to the board, and we also have to develop a form for this reporting. And as Ms. Barravon mentioned, there's some things that we're going to have to put on the MAC's agenda, including a review of the existing reporting data elements and possible changes to coordinate with other reporting systems, including MANA, and provide outreach to new licensed midwife applicants that the challenge mechanism will no longer be available effective January 1st, 2015. Is there any questions? Okay. The next bill is ACR 40. And this resolution proclaims April 9th as DMV Donate Life California Day and April as DMV Donate Life California Month, and encourages all Californians to register with the Donate Life California Registry when applying or renewing a driver's license. And we're just going to include a newsletter article on that bill. The next bill that was mentioned before, I believe, is SB 21, and this requires the UC and Riverside School of Medicine to develop a program to identify eligible medical residents and to assist those residents to apply for physician retention programs, including the Stephen M. Thompson Loan Repayment Program, as Ms. Yaroslavsky mentioned. And again, we're just going to do a newsletter article on that one. The next bill is SB 62 Lou. As you may remember, this bill was the coroner reporting bill that the board supported. Unfortunately, it was vetoed. There's a copy of the veto message in your packet. This bill was vetoed not for policy reasons, but for fiscal reasons, because it ended up being tagged as a state mandated local program, which means because there was cost to the coroners that it was going to be something the state would have to pay for. We did everything we could not to make it a cost, and we were trying to work to make it easy for the coroners. So we were going to develop a form that they could just email over to us, but this is something we want to continue to work on, and I'll talk about it a little bit more in our 2014 legislative proposals. Okay, and the next bill, SB 304, Lou. I know we've discussed this bill at length on the transition of investigators. So I'd really like to just focus on the implementation plan, unless anyone has more questions, just on the other provisions of the bill, not on the transfer, because I think we're all clear on what the implementation plan is for the transfer. Okay, so as you know, this bill includes language, which a lot of the provisions that were included in the board's sunset review report. So this bill removes the sunset, or extends our sunset date till July 1st, 2018, It removes the sunset date for vertical enforcement. There are also some issues that weren't in our sunset report that were included in the bill kind of at the last minute. One of them is that it requires the DCA director to approve the employment of the board's selection of an executive director if that person is hired after January 1st, 2014. It also included language regarding medical graduates, international medical graduates who attended a disapproved or unrecognized school. It changed that requirement for those that attended disapproved school. Existing law is 20 years. It changed it to 12 years. And then, as we discussed, the transfer. So the board's implementation plan is we will notify and train board staff of all the new requirements. We will also work to notify interested parties. We will update the board's website to reflect all new changes to law that are included. We will be revising the license renewal form to require email addresses to be reported if the physician has one. And we also have to develop a process procedure to send out a confirmation email to all physicians on an annual basis to ensure the board has the correct email address for each physician. We will develop a process procedure to ensure that 801.01 reports are excluded from the requirements in existing law that require an upfront review. So we will notify our investigative staff of that requirement. And lastly, we will work with the AG's office and notify the AG to seek ISOs when a licensee fails to comply with an order to compel a physical or mental examination, because this is now constitutes grounds for an interim suspension order. So just if they just fail to comply with that, then that's grounds for an ISO. So are there any questions? Okay, I'm going to move on to the next bill then. SB 305 Lieu. Among other provisions, this bill allows all boards under DCA that require licensees to submit fingerprints, including the medical board, to request from a local or state agency certified records of all arrests and convictions, certified records regarding probation, and any and all other related documentation needed to complete an application or licensee investigation. This bill specifies that a local or state agency may provide these records and that the board may receive these records. And again, we're just going to notify trained board enforcement staff of this law. Okay, the next bill, SB 352 Pavley. This is the bill that allows physician assistants, nurse practitioners, and certified nurse midwives to supervise medical assistants. And on this one, we are just going to update the information on the board's medical assistant website page and then again notify trained board staff. Next bill, SB 493 Hernandez. This is the bill that expands the scope of practice of a pharmacist to recognize an advanced practice pharmacist, permits pharmacists to furnish certain hormonal contraceptives, nicotine replacement products, and prescription medications for travel, and authorizes pharmacists to independently initiate and administer certain vaccines, among other provisions. The board's implementation plan is to notify trained board staff and to work with the Board of Pharmacy and other interested parties to develop standardized procedures or protocols for furnishing of self-administered hormonal contraceptives and nicotine replacement products. Moving on, SB 670 Steinberg. This bill authorizes the board to inspect the medical records of a patient who is deceased without the consent of a patient's next of kin or a court order in any case that involves the death of a patient, and revises the definition of unprofessional conduct for a licensee who is under investigation if the licensee repeatedly fails to attend and participate in an interview for the board. Again, we will run an article and notify attorneys who represent physicians of this new bill, notify trained and board staff, revise existing processes and procedures regarding obtaining records for deceased patients. We'll have to develop a declaration to include with the written request for a deceased patient's records, and revise existing processes and procedures for scheduling physician interviews, as this bill no longer requires mutual agreement. As you probably know, this is the bill that would have allowed us to limit a physician's prescribing privileges, but unfortunately, at the very last minute, that part was taken out. And so Senator Steinberg tried to get it through with that in, and it just didn't make it. So it still gives us some good things that we can work with that will make enforcement a little bit better, but it doesn't include everything that was originally in the bill. Okay, the next bill, SB 809, I know that we kind of had a discussion on this and the money that we're giving now and what's going through, but just to refresh your memory, this bill would consist of a $6 annual flat fee collected from all licensees of boards, including physicians and the medical board, for purposes of funding and upgrading the CURE system. This bill requires DOJ, DCA, and the regulatory boards to identify and implement a streamlined application and approval process to provide access to cures, requires the board to periodically develop and disseminate information and educational materials and information on cures to each licensed physician and general acute care hospital, and requires prescribers and dispensers before January 1st, 2016 to submit an application to DOJ to obtain approval to access cures information. The board's implementation plan is to post information on the board's website regarding the fee increase and email physicians, to notify trained board staff, to revise the renewal application form to reflect the new fee and revise the renewal letter to reflect their new fee, to make necessary changes to the computer system to reflect the fee increase, to work with DCA, DOJ, and other regulatory boards on a streamlined application process for cures, and provide recommendations on how this application could be integrated as part of the license and renewal process, to work with DCA, DOJ, and other regulatory boards to develop a procedure to enable healthcare practitioners to delegate their authority to order cures reports, and develop an opt-out procedure for those practitioners who do not have a DEA number. We will also provide input to DOJ and DCA on desirable capabilities in the new cure system for the board's enforcement program, and work with DOJ and DHCS to identify educational materials related to assessing a patient's risk of abusing or diverting controlled substances and information on cures, and disseminate those to each licensed physician in general acute care hospital.
Thank you. When does the increase in fee start? January 1 for renewals?
It is April 1.
April 1.
We told them that we needed a little bit more time because we send our renewal notices out, 90 days in advance, and so they kind of just gave us that 90 days, basically.
And when do these funds start going to the DOJ for the improvement of cures program?
Well, as Kim mentioned, the medical board has already given some funding, but what the bill does, and I didn't read everything the bill does, but it establishes a fund in Department of Justice. So although we'll collect those fees, it will go directly to that fund at DOJ. So as soon as those new fees become in effect, that money will start going to, even though we're collecting it, it really doesn't go to us. It goes straight to this DOJ fund.
Yeah,
Does that answer
I'm
your
just
question?
trying to see that, when can we really get that system working? And it doesn't look like before 2016.
I mean, it's going to take time because, as they mentioned before, we have that initial money that's already in the budget, and that's for really start building that new system. But this annual fee on all licensees is really for the maintenance and the ongoing funding. So the funding's already there for the new system, but as Ms. Harold and Ms. Kirkmeyer kind of explained, it's going to take some time. We're working on the FSR now. We have to get input from all the boards. So the funding for that new system is kind of already started. It's just we have to go through the process. So this is really just for ongoing costs and maintenance.
And this is a replacement system.
Mm-hmm.
It is not an upgrading of a broken, not broken, but an outdated system that was built in.
And we all know new systems sometimes take time, as we've heard with Freeze. So, I mean, it could take some time.
So my question would go to the fact that this was the bill that is only charging licensees, and Big Pharma is not part of this, and retail pharmacies are not part of this, and corporate America is not part of this, correct?
Yes, correct. And although we mentioned that, it's just they didn't end up getting included in the final version.
And also, it includes all licensees regardless of whether they prescribe scheduled drugs.
No, thank you.
Yes. Mm-hmm.
Thank you.
Yeah, unfortunately, it looks like we did fail on that. That is including the Big Pharma. That's where we should have get some significant funds because that's where the money goes.
And DOJ, I mean, to their credit, I was in a lot of the working group meetings. They really tried, but it's just if they wanted to move this bill forward and they wanted cures in order to get that done, it wasn't going to happen. It almost didn't pass out of one of the committees with that language in there. And as sometimes happens, you have to it's a negotiation getting bills through the legislative process.
So there is still the opportunity for voluntary contributions.
Correct.
And from industry, and I suspect there will be some effort made to get some of our colleagues in the drug manufacturing industry to put up some good faith signals that they're
I would
willing to.
suggest that we also don't forget the insurance companies in the opportunity to participate, since they directly benefit from people, from people knowing who's doing what to whom with what. And since they pay our insurance, the automobile insurance, our healthcare insurance, in all due fairness, I think that hopefully that with the increased needs of this new system to be going forward, that they are, that we don't walk away from an opportunity to ask.
Okay.
Yeah, Madam President, I think I don't believe in tooth fairy, but I think as the system develops, that's when I think we got to go after to the pharmaceutical industry and the insurers to put in more money to make the system more robust. We are looking at this as the seed money to really get the, not just to get the program going, to maintain the program, but it needs to be fairly robust without any problems, just logging in very quickly and really seeing what we need to see.
All right, I'll move on to the last bill. SCR 8, Desagné. This bill proclaims the month March each year as Prescription Drug Abuse Awareness Month and encourages all citizens to participate in prevention programs and activities and to pledge to spread the word one pill can kill. And this, we're just really going to, like we said, the newsletter article, but also we're going to develop and identify outreach materials for dissemination in March 2014, as that is the month that's identified in that resolution. So is there any questions? That concludes my 2013 legislative presentation. Should we do public comment now, or?
Ms. Cleverell?
I hear you mention that the cure system is a new system. I didn't see anything in any of the documentation would describe that as a new system. I just see that they will finance it and so on, but in nowhere, and maybe you can show me where it is, because I don't know, I have not seen it.
Yeah, I'm saying this based on the reality that this is not a fixable system. And so I believe that the RFP that's out describes the building of a system rather than the upgrading of a, we've used the term upgrading loosely, but it really is about building a 21st century system rather than putting Band-Aids on it.
Any way we can access the RFP?
I have no idea.
When it actually goes on the website as a contract or as a request for proposal, those usually are posted on there. So you should be able to, it would actually be under the Department of General Services.
Okay, thank you very much.
Okay, moving on to
I'm sorry, Ms. Sparavon had a comment.
Thank you. Carrie Sparavon, Chair of the Midwifery Advisory Council. It occurred to me when Ms. Simoes was talking about AB 1308 that some of the board members might think that licensed midwives used to do other than normal and now can no longer do normal. We've never been permitted by law to do abnormal or care for women that fell into that category. What is different now in AB 1308 is because there has been debate over the years about what exactly was normal. There are some items now that are delineated in statute as to what normal looks like. The midwifery standard of care for licensed midwives that was adopted in 2005 has a fairly extensive list that was developed in conjunction with ACOG in 2005 as to those conditions that may affect a pregnancy or delivery. So I'm hoping that we will revise the standard of care to come in line with the law. Thank you.
Thank you.
Okay,
proceed with 2014 legislative
Yeah, 2014 legislative proposals, and that's the last tab in your legislative packet. So first I'm going to go over some sunset review proposals. The board included new issues in its 2012 sunset review report to the legislature and in the 2013 supplemental report. These reports were submitted to the legislature, and the legislature prepared a background paper that raised 39 issues, some of them related to the new issues included in the board's report. Some of the new issues were included in the board's sunset review report that would require legislation were not included in our sunset bill, SB 304. So the board staff has identified the following proposals to move forward in 2014. So for each item, I'll need a motion to move forward with that. So the first one is in the board sunset review report, the board recommended that in the interest of consumer protection, legislation be written to require that regulations be adopted for physician availability in all clinical settings, and for the board to establish by regulation the knowledge, training, and ability a physician must possess in order to supervise other healthcare providers. And this came up in our Committee on Physician Supervisory Responsibilities. We were mandated by law to do the physician availability regs, which we have done, but only for a narrow amount of settings. And in discussions there, it was discussed, why don't we do this for all settings and not just those using laser and intense pulse light devices. And also it was discussed that there should be something established regarding knowledge, training, and ability. So this is that proposal since it wasn't picked up in our sunset bill.
So moved.
Second?
Yeah, second.
Was
but
there a second?
I also wanted to ask, what are, just explain to me what the all settings are. Just what are the, I'm trying to still figure out what are those settings.
Well, it would be anywhere where a physician is practicing and using mid-level practitioners. So the physician availability is, you know, like kind of what we discussed with the PA regs that were modeled
So
after
this is
our
for
own.
supervision, mainly. Okay.
Correct. Any other questions from board members? Any public comment on this proposed legislative proposal? Seeing none, all in favor?
Aye.
Aye. Any opposed? Any abstentions?
Okay, thank you. The next one, so I kind of briefly went over, is a coroner reporting issue. And like I said, this bill was vetoed. We supported it. It was vetoed for fiscal reasons. Board staff would like to continue to work with the Senate Business Professions and Economic Development Committee on this important issue. I don't think I necessarily need a motion, but just wanting, do I need a motion? Okay, I do need a motion to work, because I'm not sure that Senator Liu is interested in doing another bill, or if he would like encourage coroners to, you know, just voluntarily provide, but whatever direction he wants to go, that the board can support that and continue and help. Yes?
Let her finish what
Okay.
she's saying, and then.
Just that we would like to continue to work with them on whatever their interest is in moving forward.
So could you state the motion you want?
So the motion would be to support staff working with Senator Liu on whatever direction he wants to go with the coroner reporting.
In relationship to coroner reporting, okay.
I just wanted to amend the motion to
And I want to
also
amend it to-
work with the coroners. I mean, that is an important issue. I think we just can't mandate certain things on them, and
Yeah.
that's where the biggest opposition was, and also was from physicians of California. So that's why working with the coroners is the way to go if we want something done there.
And I actually think that's kind of the direction Senator Liu is working towards right now, which is why I don't want to say a bill if that's not the direction that he wants to go.
I would ask also for an amendment that while you're discussing this, that it shouldn't just be limited to coroners, that it should be limited to all first responders.
Okay.
So moved.
Ms. Wright.
With the
Oh,
amendments on
thank
the
you.
motion.
So Ms. Wright is moving the amended motion and the amendments include explicitly including the coroners and raising the issue of all first responders and how to approach that. Dr. Lewis.
When you, Ms. Jeffersowski, when you say first responders, you mean any person who happens to
Talking about all
arrive
law
at
enforcement officers.
law enforcement versus a lay person or anything? So first responder
First
is
responders, like
a law
Fire
enforcement.
department, sheriff's department, police
Okay, good.
department.
I just want to be clear because it could be public.
Yeah.
Okay.
Yeah, EMTs. I think my definition is what's,
Good.
So it's a term of art.
it's a term of
First responders. Ms.
origin.
Kirkmeyer.
Of origin, yeah, right.
Can I ask for clarification from Ms. Yaroslavsky? So the reporting that we're asking for from the coroners is if they find a death that deals with prescribing issues. But are you talking about those that are the first responders that find that there's a problem with prescribing not related to a death? Or are you talking about
We don't know if
a
the person will die or not. So if a
That's
law
what I
enforcement
thought.
officer shows up at a site, there's someone on the floor, the person may live, person may die. There are prescribed drugs in the location, and the question then becomes, Just as if you were to have a fire in your home and the fire department put out the fire, they would hand over the investigation to
Can we separate that? Can we have a separate proposal?
I'm
So,
ju-
because the coroners is really kind of a specific issue.
I agree, but by the same token, people die as a result of.
Not
people-
challenging the merit of what you're saying, just trying
Not
to,
everybody goes to the coroner's office,
keep-
so my concern is to make sure that all people that are involved in drug-related overdoses or deaths be requested to participate in this.
Complementary motion.
So I'll do
Yeah.
a separate motion, if that's what you prefer.
if we can just separate the issues, because there are a specific set of issues and work already in progress with the coroners. The issue of first responders to a situation where the patient is likely alive or maybe alive.
For
Fire-
a few minutes or
Yeah.
a few hours.
Okay, so let's separate those. Dr. Yip?
I was going to suggestion we should separate coroners one, but I think the staff had direction working with legislature in the future, like the hospital has responsibility, physician has responsibility to report like child abuse, suspected child abuse, etc. So I think down the line we should have not necessarily first responder, but physician and hospital has responsibility to report suspected drug overdose related to improper prescribing.
That's a third motion.
It's different, just a suggestion of the future.
Dr. Krause?
I'd make an editorial comment to agree that we want to focus on coroner's reporting, but perhaps the board could establish some policy that going forward we're really interested in all avenues of potential reporting of opioid misuse or overprescribing, rather than to try to narrow our focus at this meeting.
Okay, so we have,
Once we get to the second one, I'll make the motion for that one as well, but for now, the corners, I'll make.
so we got the, to include the amended motion to including the coroners in working with Senator Liu's, everybody's a doctor in my world, Senator Liu's staff. Any comments from members of the public? All in favor?
Aye.
Opposed? Hmm?
There was no.
Abstention?
Was there a second?
Dr. Lewis seconded.
Oh, you did, okay.
Yeah. Okay, so we now have a proposal from Ms. Yaroslavsky, seconded by Dr. Krause, to consider more broadly issues related to other is that okay, Barb?
Sure.
Other sources of information about morbidity and mortality related to prescription drug abuse and potentially prescribing issues.
Madam Chair, if I could speak to this, the difficulty, having served as a first responder, first as an EMT, it's very difficult. That's not their job when they respond. They will not go hunting around looking for prescription medication. They simply want to treat the patient, and they will transport the patient and leave that up to the hospital to determine what the cause of the problem is. So I think we'll get a big resistance from our paramedics and fire departments and police, because police are considered first responders as well. But I do think that that would be problematic. But I also think on the coroner issue, too, as Barbara was saying, not all cases go to the coroner.
That's true.
And so the difficulty is that while I understand the intent, you've got to have some trigger mechanism from the hospital to rule it a suspicious death or something related to this to refer it to the coroner. Otherwise,
So my concern
nobody's going to do any
is
kind
the
of
la-
further.
is-
Nobody's doing any further investigation at that point.
My only concern is the collaboration or the lack thereof. We don't really have oversight over law enforcement. We just don't. I understand that. We don't have oversight over hospitals. We have oversight over doctors. But as we're going forward and working together with the Board of Pharmacy and the other allied health fields that do prescribe, it seems to me that we just shouldn't shut the door on the opportunity for more information. And so I will go with the board doing a separate, but I understand that doing a separate, you basically are walking away from that because we don't have oversight.
So may I make a suggestion then? Can we create or move to maybe consider creating a task force to explore this so that we can have more information and evaluate, so that we can have an informed answer before we say yay or nay?
So, really good suggestion, and we have a prescribing task force, and we can ask Dr. Bishop and Ms. Yaroslavsky to incorporate
Or something.
conversation about this. And my only comment would be, not everything is a legislative solution. So that there may be opportunities to enhance reporting, increase awareness without creating a mandate on firemen and
Right.
police officers. But
We're doing it on the corners.
right, well, because we've had, I agree. I mean,
It seems the problem is that the state is very quick to legislate rules and regulations that have to be implemented by cities and counties, and without providing a funding source, there's definite pushback, and we saw that with Senator Lalou's. I'm just editorializing, and I apologize.
Dr. Bishop.
I think there's two categories of patients who have ill effects from prescription drug overdose: those that die and those that almost die. And those that die are going to go through the coroners, I presume. Those that almost die typically are going to be picked up by a first responder, whose responsibility, I agree, Jerry, is not to worry about that. But when it does get to the ER or the physician, as Dr. Yip's already mentioned, that physician will consider, as they do their lab work and evaluation and get history and physical, whether or not they feel that a prescription overdose could have been responsible, at least in part, for this problem. And at that point in time, we already have avenues for mandatory reporting of child abuse, elder abuse. We might consider something of that nature. This would then, and again, may not legislate, but I'm saying, I think what Dr. Yip's saying has some merit, that we should consider that reporting that second category of patients of the almost dead. I think we then get the dead and the almost dead, and it's going to take care of most of the problems that are of great significance.
Well, that sounds a little bit different than the prescribing task force to me, which is why I made the suggestion about maybe a subsection of the task force. But I'm sorry. I said it sounds a little different than the prescribing task force to me, which is why I made the suggestion of a subset or a separate task force, because this is it's sort of a narrower issue. So, but I mean, you know, I'll defer to however everybody else on the board feels, but I feel like this is a very separate category.
Dr. Bishop and Dr. Yip's focus on putting it in the responsibility at the hospital, we don't currently have something like that. So actually that would also take the place of the first responder, not having to report anything. It would be a place that it could be captured, so I appreciate that. That's the
I
recommendation.
think the key thing is save the one who may die. The one who died, then.
Sharon, maybe we put some closure on this. You're going through committee assignments now, I think. That was part of your president's report. So incorporate these comments, and once you make your appointments and committee assignments, you'll delegate this subject matter to the appropriate task force or committee. If you're comfortable with that.
Yeah, I'm still trying to process some of the comments. So, Ms. Wright raises the question of whether this appropriately fits within the prescribing task force, and the nexus for me is that there are the issues the hospital and physician deal with, which is saving the life of a patient who has taken an overdose. Getting a cures report on the patient and looking for evidence. I mean, there's an investigative piece around, is there evidence in a cures report of a patient who has taken excessive amounts of a prescription drug that suggests there's a prescribing issue, which is what which to me is the nexus. So how do we, what's mandating reporting by doctors and hospitals in that setting? There's got to be some thinking through of what the policy is and what the workflow process is. I'm just worried about taking a complex set of issues and summarizing it in a simple sentence.
That's my concern. I mean, there is so much in prescription drug overdose. And if anybody thinks that it's all related to a physician prescribing, they are just somewhere in a frog in a well syndrome. It's not that way. It's a complex issue, and in that complex issue, medical board fits in as a partner with many others. So I think this issue is just for us to only take it on and try to come up with a solution is very difficult. So maybe staff can work with, or you can have a task force to really recommend certain things to see what to look for. But I think for us to take on a complex issue, especially in reporting from hospitals, from the first responders, from everyone else, it just worries me.
So I think I have a proposal on the floor, actually, from his right,
Yes.
to establish a task force.
And I would almost add in maybe looking to some of the other boards to see if we can do some kind of joint task force, if we can, that can alleviate some of the stress from our board and also include the expertise from the other boards as well. If we can, I don't know if we can.
Yeah, and it's not just boards, it's a multi-stakeholder issue, including the hospital association, the medical association.
Well, maybe when it comes down to the prescribing task force, that this is just a subset of the task force, and that we bring in some
Yeah.
collaboration efforts there, and I would thank you
Agendize
for
it.
that, but let's maybe just, Dr. Bishop and I should have a conversation with staff, I think, and see about
Because it
putting this
really is
together,
a-
because I have had, I just want the board to understand this, I have had the conversations with first responders, and that's why I bring the issue forward, because currently, there is nothing in place for the person that responds to someone's home and sees legal prescriptions in that home and has to send that patient to the hospital. They do call the hospital and tell them what they see, end of discussion. I'm not going to the hospital part, I'm going to the drug, an overprescribing drug part. So I'm really not talking about, so I will definitely move with Dr. Bishop, and we'll talk with staff and figure out how we can build on this, and we can take this off the agenda, and I apologize.
And the task force could create a sub-task force with
Sure.
different board members.
Sure.
Dr. Kraus?
I'm not sure that we approved the motion to authorize continuation of working with Mr. Liu. Did we
And we
vote
haven't
on
gotten
that
there
and
yet.
approve that?
I think we did.
And then secondarily, before we leave this discussion, I think it is useful for this board to express its concern by either a affirmation or reaffirmation that we wish to explore and exploit all potential avenues of evidence of overprescribing. I think that the public needs to know how important that issue is to us, and that we need to have some public affirmation of that position.
For the record. Thank you. Oh, right, and we have, I mean, one of the, Ms. Kirkmeyer's reminding me that one of the sources of information we're now getting is, for example, from manufacturers who've created lists of suspect prescribers and who've directed their reps not to detail controlled substances to those physicians. Purdue Pharmaceuticals has provided the board staff with a list, and CVS, the national chain, also has a process for identifying potential hotspots, and they have agreed to share they have shared their information with us. Their list is much smaller, actually, but, okay. Did we approve your motion?
I think we did the first one about working with Lou's office, so if there's no other motion needed for the second one.
Okay, great.
All right, so moving on, unless, do we need to take public comment, or?
Oh, sorry, public comment on the motion, which we've approved, and should have asked for public comment before we approved it.
I think we did that
We did that.
appropriately.
Okay. Thank you.
So we've had
Okay,
further
we're good.
discussion.
Okay.
So-
Let's
Okay,
move
moving
on.
on then. Okay,
Well,
this, no.
We should make sure that there's no public comment on the further discussion that we've had before we move on.
Is there any public comment on the further discussion we've had before we move on? Ms. Felmuth.
Thank you, Dr. Levine. I just wanted to throw in one last footnote on this first responders, other folks reporting requirement. We wrote the bill in 1990, Senate Bill 2375, which established the first coroner's reporting requirement. And we included that provision in our bill at the request of the Coroners Association. They wanted a mandated report requirement, but they also wanted immunity from liability for reporting. So whenever you create a reporting requirement, the person required to report is going to want to be immune from lawsuits for making that report. So just to throw that into your mix. Thank you.
Which often means the bill dies.
There'd be no
Saturday for them reporting.
And then the bill dies.
Okay.
Okay, proceed.
Okay, moving on. The board recommended elimination of the 10-year posting requirement in existing law in order to ensure transparency to the public. In the BMP committee's background paper, it was recommended that this actually be included, but SB 304 did not end up including this language, so we're requesting to move forward. This could be a potential omnibus candidate or something like that, maybe not a standalone bill, but we're requesting approval to move forward with this legislation.
Do I have a motion? Dr. Lewis? Second? Dr. Bishop, any questions or comments from board members? Is everyone clear on what eliminating the 10-year posting requirement means for the new?
It'd be worth a review for the
for the new board members. Could you?
So what in law now it says that we only post stuff for 10 years, and so even though it's available, if a consumer calls our file room, that is still a public document and that's still a public record, but we just don't post it on our website. So to be transparent, we would like to be able to continue to keep the information up that's public on our website instead of requiring the consumer to call our central file room. It just seems a little onerous on the consumer, so we would rather, if that document is public, post it on our website.
Okay. Any comment from members of the public?
Michelle Montserrat Ramos, Consumers Union California Safe Patient Network. We support your proposal, and in Lloyd's case, his physician's judgment was just removed like months ago. So what we're asking, if this could be included in the proposal, was that some of this information be retroactive, whether it's in the past 3 to 5 years or so. If you could include some of this information be retroactive, it would be helpful. Thank you.
Thank you for your comment.
Karen Ehrlich, licensed midwife. A couple of times in the last year or so, I have tried to come up with the public documents having to do with cases that previously were easily linked on the website. I could look up a licensee's identifying information and it said go to the public records. And it seems like that's been removed because lately I have not been able to find those public documents.
So this is part of the new Breeze transition, and so if you scroll down to the bottom of the page now, where it was up at the top, and you'd go across the tabs down at the bottom, there lists public record actions, and you'll see 1 found, 2 found, none found, but when it says 2 found, you click there, it takes you to another screen, then it talks about those actions, and then you click there, and then it will pull up the documents. So Karen, I can walk you through it later if you want.
Thank you.
Great. So we have a motion and a second. All in favor?
Aye.
Aye. Any opposed?
Okay, great. Okay, moving on to the next one. In the board sunset report, the board recommended amending existing law to require a respondent to provide the full expert reviewer report and to clarify the timeframes in existing law for providing the reports. SB 304 did include this language. And it would have required the complete review report, and we defined what a complete review report consisted of. And we actually met with CMA. They had some issues on our timing of it. We worked to address some of the issues they brought up, and so we made it 90 calendar days prior to the commencement of the hearing. However, after several meetings with CMA, we couldn't come to a consensus, and so it got dropped from the sunset bill. So we would like to come back and work on this again next year. Because, you know, we did meet and we did take some of their revisions, but we'd like to continue to work on this issue.
And I
legislation.
assume you're proposing working with CMA to reach
yes
agreement. Okay, can I have a motion?
So moved.
Oh, second?
Second.
Any other questions from board members? Any questions from members of the public? All in favor? Aye. Opposed? Abstentions? Okay.
All right, thank you. The next one is a technical one, but in our supplemental report, we recommended that existing law to be amended to include American Osteopathic Association Healthcare Facilities Accreditation Program as an approved accreditation agency for hospitals offering accredited postgraduate training programs. This was in our supplemental report, so it came after the background paper. So because of that, language just didn't get included in 304. This is a really technical thing, so it would probably be an omnibus candidate, but I just wanted approval to move forward with that.
Can I, Dr. Kananadev, thank you. And
Yeah, they're actually one of the CMS accredited agency to accredit hospitals, so I thought it national law, so does it need to be in the state
Well,
law?
we have to conform to, state law has to conform to federal law, so.
So moved. Second. Ms. Yaroslavsky, thank you. Any other comments or questions from board members? Any questions or comments from members of the public? Seeing none? Ms. Simoes? Oh, all in favor?
Aye.
Opposed? Abstentions? Ms. Simoes?
Okay, and we have a couple of proposals related to outpatient settings. You heard the update yesterday from the Outpatient Settings Task Force, so you know that we're working on a number of other proposals, and we're going to be working on an interested parties meeting, so I'm not going to mention those, but there is something that's been brought to our attention, and I think we briefly discussed it, that existing law requires surgical clinics, those are the outpatient settings licensed by CDPH, to report aggregate data to OSHPD. Well, when Capon versus Shuri came and those physician-owned clinics were now required to be accredited by us, they fell out of those reporting requirements. So they were no longer required to report that information to OSHPD. And the data includes number of patients served, number of patient visits by type, patient charges, and additional information. And so what we would like to do is require this for our accredited outpatient settings. And we'll have to look at the data elements to see that, you know, what actually we should be asking, but we would like to put in place for accredited outpatient settings because it's severely, that data is just not available anymore for our accredited outpatient settings. And it was something that was brought to our attention that we would like to move forward with.
So just to clarify, we would be requiring the accrediting agencies to require of the centers, or the regulation would require the centers?
I believe it would require the actual centers to report that data to OSHPD.
Directly to OSHPD.
Yeah.
Why OSHPD, why not to medical board? I'm
Because
just curious.
OSHPD is usually the collectors of that kind of data, and so they already have systems built for it, and they already collect it from licensed surgical clinics, so it would just be adding accredited outpatient settings, and it's also as part of this, of course, we would work closely with OSHPD too to make sure they're on board with the proposal.
Dr. Krause.
I agree, and the advantage of reporting to OSHPD is they're very good at data mining and analysis. So if OSHPD has the data from all of the outpatient surgical settings, whether they be hospital outpatient department or ASC, physician-owned or not physician-owned, it'll be easy for us to compare statistics in different settings.
I think that's really important, and to look at whether there is variation in outcomes based on ownership, for one thing. Dr. Gananadev.
I think either California Endowment or California Healthcare Foundation had a study on the outpatient surgery centers. And since that lawsuit which transferred to medical board, everything dropped off. There are no numbers, so that's why it's very important to get those numbers in.
Ms. Yaroslavsky, did you have a comment?
Yeah, I do have a question. I agree that it needs to go to OSHPD without a question. They're the ones that the receptor of all this kind of information. But I'm wondering about the need to have it reported back to us on a yearly basis. If that is something that the staff feels that there may be an annual, we have to report annually to them stuff on different kinds of things. I think that somehow, especially with the oversight of surgery centers and the need for oversight, that maybe an annual report to this board should be part of that.
I think we can work with OSHPD on that. I don't want to do any kind of mandate on them that's going to require a fiscal, but I mean, I think it's something we could work with OSHPD on how we can get that information back.
Great. So we have a motion, we have a second. We don't have a motion. Yes, Dr. Gananadev moved it.
Yeah.
And I believe Dr. Krause seconded it. And we've had comments from the board. Any members of the public
Lisa McGiffert with Consumers Union Safe Patient Project. We strongly support this recommendation. As we spoke to you about it earlier, we'd also urge you to consider, maybe you have to consider it at your next meeting, to add the other issues of reporting that we suggested in our testimony that we presented to you in writing, with regard to reporting deaths and hospital admissions within certain periods of time and adverse events, so that the board is aware of those things.
Thank you very much. So I think we're ready for a vote if there are no other comments from members of the public. All in favor?
Aye.
Opposed? Abstentions? Ms. Simoes?
Okay, thank you. And the next one has to do in a little bit what Consumers Union was just talking about. So existing law requires a physician who performs a scheduled medical procedure outside of a general acute care hospital that results in a death to report the occurrence to the board within 15 days. The board would like to ensure all deaths in outpatient settings are reported to the board, not just those that resulted from a scheduled medical procedure. So board staff is suggesting striking the scheduled before medical procedure from law. And this could be, again, maybe an omnibus candidate.
So move.
Second.
Questions?
Dr. Lewis.
I have a question. On Business Profession Code 2240, it says in your outline that occurs in a outside acute care hospital, right? Is there a period of time where it's still considered under that period?
Well, it just is, I don't think it's specified in, I don't have my law book.
I'm looking, I just didn't know whether it's that moment in time or it's that moment in time and beyond.
I think it's that moment in time, right?
So the question is whether this applies indefinitely?
Well, no, is there a period of time? Because it just says when the death occurs.
You mean like if a patient were to go home?
Go home
Yeah.
in 24 hours, something happened.
This is just in the outpatient setting.
Outpatient setting itself, while they're actually there. Okay, right.
And I believe removing scheduled would address some of what our colleague from Consumers Union Safe Patient Project addressed.
Yeah, and just so you know too, SB 304 did include the adverse event reporting to the board, so that one is covered in 304.
Okay.
Moved and seconded.
It's been moved and seconded. Members of the public have commented. We're ready for a vote. All in favor?
Aye.
Aye.
Opposed? Abstentions? All right.
All right, that concludes my presentation on 2014 legislative proposals, unless any board members have anything to add.
No, it's a great job.
Thank you. The last item is agenda item 29C, and that's actually in your board packets, and that's the regulation matrix. The only regulation on that matrix right now is the SB 1441 regulations, and I think everyone kind of knows where we're at with that. And so unless any members have questions, that concludes my presentation.
Thank you very much.
Good.
We're going to move on. Oh, actually, I want to insert an agenda item, and it's been brought to my attention, and why I didn't realize this myself, I'm not sure, but our next scheduled board meeting is February 13th and 14th in San Francisco. The 14th is Valentine's Day, which for some people is a religious holiday.
Definitely not in my household.
And so I just want to, and it is also the Thursday, Friday prior to President's Day weekend. And I want to be sure that this is not going to create problems that will force us below a quorum. We need to be able to conduct our business. So we voted on at I believe our April meeting to accept these dates. But I want to be sure that everyone is aware of this and that you are not aware of conflicts at the moment that would prevent your attending the San Francisco board meeting. Dr. Krause.
My wife celebrates Valentine's Day 365 days a year.
Smart woman.
Any board meeting interferes with her happiness, and I have no objection to keeping February 14th.
So I, on the other hand, probably will have a conflict, not because of Valentine's.
Is there anyone else who has a conflict?
I mean, if we can change the date, it's usually better, but I pointed out this morning I think yesterday when we were looking at, but everybody said, yeah, we're okay, so that's why I just left it alone.
So in order to change it, we'd have to,
Do you have a motion?
do you want to move it up a week?
I'd be fine with that, or put it back a week, at the end of
So
February.
we would be, so we would be moving it to the 6th and 7th of February. Does that work for people? Is anybody aware of a difficulty with that? You do? Oh, that was a thumbs up, all right. Thank you. Dr. Kraus.
I would like to announce that I already have a teaching commitment on February 7th, but I will yield to the desire of others.
How about the week after the 14th? No?
Can't move it.
Can't move it, okay.
You can't move it that far
I'll
out.
try, I have a wedding, so that's not mine, but, you know, our son, so.
So are we keeping
that's
it or are
important.
we moving it?
I don't have a motion for either, so,
So it'll be what it'll be.
so so we've got, you will be unavailable on the 7th.
Yeah, I'm responsible for teaching a large course on the 7th.
Are you available on the Thursday?
I'll try, I don't know,
Thursday.
it's his first son that's getting married, so I don't know.
Oh, that's right. We'll have it at the place.
Maybe they can move their wedding.
Okay. Here's I'm gonna really break with precedent. Can we do Wednesday, Thursday? Would that work for people?
No.
No.
I just want to remind people that leaving on a holiday weekend just increases your traffic. That's fine. I mean, I'm fine to do what I can do, and don't change it because, you know, I would appreciate it, but just keep in mind perspective of transportation. Not from the airport, not in the air, but after you leave the airport.
We're gonna meet at the airport.
Well, as long as there's no cloud cover in San Francisco in January.
So now this feels like Solomon with the baby here. I've got.
No, leave the dates. Thank you very much for trying. Leave it. Well, you know, if I can't, I can't, and I'll try.
7th, 6th, 7th is, that dates are better for me too, like, I got AAMC meeting, so I have to go to.
We'll leave it
On
as.
13th.
On the 13th. So you're not available on the 13th either, Dr. Gananadeb?
Yes.
I will excuse my anticipated absence, if you will.
Yes. All right. I think we are going, so could someone make a motion to move this to the 6th and?
I'll make the motion.
Thank you, Ms. Wright.
I'll second that.
Dr. Gananadeb, second. All in favor?
Aye.
Opposed? No abstentions? Okay, thank you. So we've resolved the holiday conflict, and I'm sorry, Dr. Kraus. Appreciate your
miss you, Dr. Kraus.
enthusiasm and willingness to serve. Then we can move on now to agenda items for February 6th and 7th meeting. It will be in the San Francisco Bay Area. We're looking at, I believe, a place in Foster City.
Oh, good.
And we have two items already on the agenda. A presentation from the Department of Healthcare Services, a presentation on fraud, which comes up often or occasionally in the cases that we describe. We'll have a presentation by Linda Schneider from the Department of Consumer Affairs, Attorney General's Office, sorry, educating us on the registered dispensing optician issues and the lawsuit that was settled and the implications for the board, and a presentation by Dr. Catherine Nation, as I mentioned, on graduate medical education and the status of funding of slots for the sources of funding and the status of slots, funding for slots in graduate medical education. Do board members have any agenda items they'd like to be placed on a future agenda?
Can we get an update on Covered California?
Thank you. Good suggestion. By February, there should certainly be information, and Covered California is looking good.
It is.
And any public comment on an update from Covered California? Okay. Oh, right, yes, come forward. Thank you.
Lisa McGiffert with Consumers Union Safe Patient Project. We again ask that you put on your agenda discussion about notifying patients when physicians are on probation. And another agenda item that we've asked for in the past and has been discussed that we haven't heard anything about this meeting is the teleconferencing issue. And I just was wondering if we could get an update on that.
It was actually in my written report. That's one of the problems of not going over it. But we are looking to, with Ms. Shipsky's committee, since it's her, one of the things that she's been working with us on, doing the teleconference at that first committee that we're having, I believe, in November, Ms. Simos. So we're going to try it there. And then the next one we're looking at trying out is the Education and Wellness Committee meeting that we're going to try to be having between now and February. So those two meetings, that'll give us a start and a good pilot at that point, and then to see how we're going to incorporate that into full meetings.
Thanks for that prompt. Dr. Ganadev.
Madam Chair, the subcommittee for the Executive Officer Search Committee could not meet before this meeting, and they recommend to the full board the final 3 candidates. So the goal is to have that meeting, the initial meeting of 2 board members, to interview 5 to 6 candidates, and then recommend an interim board meeting sometime in late November or December to pick an executive officer.
Thank you. Okay, and I think we have gone through our agenda items. I'm just checking to be sure I haven't missed anything. As Dr. Ganadev reminds me, we will not be holding a closed session now. So I'd like to call for a motion to adjourn the meeting.
I move to adjourn the meeting, yes.
I got a motion and a second. All in favor?
Aye.
Opposed? Thank you all.
Yes.